There was a motion filed by the Commonwealth today talking about their plans for opening statements to include some of the defendant's statements. What does this mean?
What they're trying to do is alert the court that they intend to play some of the statements that Ms. Read has made in the media during their opening statements. And before they just get up there and play that for the jury, they want to make sure they clear it by the judge, because the last thing we want after impaneling this jury is a mistrial right off the bat. So they're getting a ruling from the court. Yeah, this is okay. You can play it. But they also want to know what the defense is going to play too, because they don't want to show their hand and let the defense hold their cards close to the chest. So that's the goal of this motion, really.
Mm-hmm. So do they still have to get approval from the court to use these opening statements?
That's what they're looking for. Generally speaking, what you need is a good faith basis that this is going to come into evidence, which in this situation they probably have. Karen Read is a party opponent, so these statements aren't hearsay, so they're probably going to come in. But it's a belt and suspenders kind of move from the prosecution, just to make sure that we're in the clear before we play this for the jury.
Mm-hmm. No, last time we didn't see this in opening statement. So this is a little bit of a different approach. What does this mean? What does this approach mean? And what does this mean for the Commonwealth's case? Is it kind of the tone you think they're going to set as far as the second trial goes?
All right. Last time we had a different prosecutor. Now we have Hank Brennan coming in here. He's a well-seasoned trial attorney, and he's going to put on a very strong case. Last time they didn't have these statements. They didn't have videos of Karen Read going out into the media and making statements which presumably hurt her. Otherwise, they wouldn't want to use them. So they're putting a strong foot forward, and they're going to use these statements for all they're worth.
Mm-hmm. And there was also another filing today. It was about audiovisual. I think that was also part of the hearing, the filing. They wanted to know if there was going to be audiovisual equipment used. Can you talk a little bit about that and like why that would be used in a trial?
Right. So anytime you're using audiovisual equipment, what you're talking about is bringing a TV screen in and showing something to the jury. So they want to know if the defense is going to be putting up a PowerPoint, what's going to be on that PowerPoint, what other things the defense intends to show to the jury during their opening statement. And they want to be aware of them before the defense gets up and shows them. Again, you want to avoid any situation where a mistrial is in any way possible here right off the bat. So we want to get rulings from the judge that this is okay or this is not okay before you get up and you put it on a screen. So I think it's an abundance of caution to make sure that we're starting off on the right foot here.
Mm-hmm. And as far as jury selection, day 10 now, I don't think anyone has been seated this morning, just kind of gauging off of the responses and people being dismissed pretty quickly. But obviously there's still 30, 40 people in there. What is your outlook? Do you think it's going to happen today? Do you think it's going to be another day? And if it's another day, day 11, is this kind of going a little bit longer than everyone thought at this point now?
I think generally it went a lot faster at the onset. This last juror or two jurors has taken a little bit longer maybe, but I'd imagine with just one more chair to fill, we'll be done at the end of the day today or possibly tomorrow. But in the broad scheme of things, I think at the onset of voir dire here, we were thinking this was going to take a month, and it's taken far less than that. So I think we're in pretty good shape.
Mm-hmm. And then also there was some talk of maybe having in between, jury selection and the trial starting, having a day of motions to kind of figure out, where the court stands perhaps on the motion just filed and some other things to sort out. Is that typical kind of a housekeeping day that you think might happen?
It can happen. It doesn't always happen in a trial. A lot of the times you'll seat the jury and you'll get opening statements the very next day right off the bat. But if you have a number of motions that need to be ruled on, sometimes it does make sense to tell the jurors, listen, take this next day off, get some rest, and we're going to get back to this thing after the court deals with some housekeeping matters. So it could be a good idea if you have a lot of rulings that need to be made, instead of keeping that jury sitting in a room while the court makes all those rulings, let them go home and come in fresh after that break day.
Anything else that you want to add or you think is important? I know, too, it seemed like, some other experts, too, had maybe mentioned that the focus of these media statements would be differing stories. Is that something that you could see the Commonwealth going into and pointing out to jurors?
Yeah, if Karen Read's story is changing at all from what her defense is putting forward as their defense as opposed to what she's going out in the media and saying in these documentaries. That's going to be a problem for the defense, and the prosecution and Hank Brennan is going to harp on that. Generally speaking, I would never want my client going out and making statements for exactly that reason. Those statements are going to be used against you, and they're not going to be used in a way that helps you. They're more likely going to be used in a way that's going to really hurt you.